Be in the case of Bogolubova and Bogolubova.
Yes, Mr. Turner, I'm sorry we kept you waiting for a few moments.
Not at all. Lady, my lords, this is an appeal against decisions made by Mr. Justice Peel, sitting in the family court, in reserved judgments, first of all dated the 24th of June last year, which was the substantive judgment. Then on the 30th of June 2022, which was the consequential judgment dealing with matters such as costs and permission to appeal. And those judgments are reflected in a consequential order dated the 12th of July last year. I represent the appellant wife, as I'll call her if I may, as I did below. My learned friend Mr. Howard, King's Counsel, represents the first respondent, the husband, as he did below. In effect, Mr. Howard joins forces with me in promoting this appeal. May sound a bit odd, the husband and wife in matrimonial proceedings joining forces against someone else, but your lordship, my lords, will have seen how that's come about. The real respondent is a Ukrainian bank, who we've called Privat Bank, which is represented, as it was below, by my learned friends Mr. Marks, King's Counsel, and Miss Fagianata. I trust that the members of the court have had hard copies and electronic copies, whichever their preference is, of the core bundle, supplemental bundle, authorities bundle, and a supplemental authorities bundle.
Yes, we have indeed, and if I can tell you, Mr. Turner, that we've all had an opportunity of reading extensively into the
I'm most grateful, so I shan't labour anything about
it is an important but relatively short point.
Yeah. For the avoidance of doubt, bearing in mind a point that was made by Mr. Marks in his skeleton argument, I should make you aware that the bank and its representatives have now had access to the entirety of those appeal bundles. Yes. So they have access to the same material that the court has.
Thank you.
I do want to highlight a few matters as I go along about the background. As you know, the substantive proceedings before Mr. Justice Peel were financial remedy proceedings between the husband and the wife. And I want to look in a moment at the nature of financial remedy proceedings, comparing them, as it were, with claims in contract and claims for damages, because we're talking perhaps to some extent about issues of priority of orders and judgments in this case. The parties, the husband and wife, had reached agreement as to the terms of an extremely complex and detailed financial remedy order, and they were jointly seeking the approval of the court in relation to that proposed order. And that draft proposed order itself reflects the terms of a separation agreement that the husband and wife had previously entered into after lengthy negotiations, and which itself had required the parties to enter into a reflective order. The bank, meanwhile, is pursuing the husband and a number of others in proceedings, commercial proceedings in the Chancery Division, seeking very substantial damages and even more substantial sums by way of interest. In that civil claim, the bank has the benefit and the protection of a worldwide asset freezing order against the husband. The bank nevertheless sought to intervene in the family law proceedings to prevent any substantive order being made in the family law proceedings pending the outcome of the damages claim against the husband, notwithstanding the fact that by reason of the worldwide asset freezing order, there could have been no enforcement or implementation of the proposed family order, without either a variation of the worldwide asset freezing order or its discharge, which discharge normally would come about if the proceedings were dismissed, if the bank failed in its civil claim for damages against the husband.
Now, Mr. Turner, as I understand it, the bank became parties by consent purely for the purposes of the argument about whether or not the consent order should be made.
A little
ceased to be parties immediately upon the conclusion.
It's a little difficult to discern whether the bank had really become a party. The bank was heard,
yes.
And by the time it had been heard, it had done and achieved what it wanted to achieve.
Well, that's why I asked, because on some places I read it felt like they'd simply been heard but not become a formal party, and I couldn't see an order making them a party. But then there was reference to them ceasing to be a party.
They were certainly seeking to become a party.
But when they were being heard, perhaps they didn't pursue that.
As one can see if you look at the transcript of the hearing below, learn from Mr. Howard in particular was arguing that they didn't satisfy the criterion.
I haven't seen a judgment about that, and I just wanted to sort of clear the decks on that.
Yes.
It's not a subject of appeal.
No. But of course the court has its own independent obligations to scrutinise a proposed financial consent order.
Of course. I'm simply looking at the status of the bank in all of that.
Yes.
For the purposes of those proceedings.
I mean, I'll remind myself of what the order actually said about it, but I think effectively the bank became a party temporarily for the purposes
that
only.
was what I thought.
Page 52, top of page 52.
Yep.
There we are. The interveners joined in the proceedings for the purpose of being heard. Oh, well, that's where I got the being heard from.
Yep.
Very well. Thank you. And although it says it is ordered, was there full argument by it, or about
There was argument in the skeleton
or was it more
arguments.
of a scuffle?
There was argument in the skeleton arguments. But the point was, I mean, one was pragmatic at the end because, as I say, they'd been heard. What they wanted to say had been heard. Whether it be heard in support of their application to become a party or whether it be heard as in their capacity as a party.
Thank you. Sorry to interrupt you, do go on.
It's helpful to have any queries posed. What I should emphasise at the outset is that, first of all, the nature of the wife's claim against the husband is a non-proprietorial claim, if I can put it in that way. And I shall say more, as I say later, about the nature of financial remedy claims. Equally, the claim for damages by the bank was also a non-proprietorial claim. It wasn't a situation where the bank was saying it was able to trace monies or whatever, and it had a claim to specific items or specific funds as a right. It was a pure damages claim.
What is the underlying cause of action?
Fraud, I think, my lord. I mean, we're not involved in the underlying action, but it's some form of fraud, as I understand it.
So that the lack of a proprietary claim, a tracing claim, may simply be a factual inability to trace?
Yes, it may indeed. Of course, my friend Mr. Marks will say, well, whether or not we can trace the husband's general financial circumstances reflected the fraud. I think that's what your lordship means. Yeah. But I mean, that's often the situation in cases in the criminal courts concerning asset recovery, where you find that you can specifically identify certain assets as being the proceeds of crime and other general wealth you can't. And in those cases, there's quite a lot of authority how you deal about the priority of claims between matrimonial finance claims by a wife, usually, and an asset recovery order or proceedings on the part of the CPS. But as a matter of fact, it's a non-proprietorial claim. Of course, if it had been a proprietorial claim, the bank could have intervened in the family proceedings. I mean, the most usual type of situation where someone with a third party with their own claim against assets would intervene would be a case, and it often occurs, where someone, often the parents or a relative of the matrimonial parties, says, well, I actually own this house that you two are fighting about, so it's not your asset at all. And the courts will have to decide then who is the proprietor as part of the overall family proceedings. But this wasn't a proprietorial claim, so the bank had no justification for being joined on such a basis.
Can I just ask, in relation to your emphasis on whether these are proprietary claims or not, if you're talking about a house and I have a good claim against the husband for which exceeds the value of the house, then the true assets available to be split between the husband and wife are zero? Or is that wrong?
If the only asset is the house and a third party has a propriety in...
No, not a proprietary claim. Just a claim for damages, which is a good claim, but I just haven't had it tried yet. Properly analysed, assuming that the house is in the husband's name, that the assets to be divided as zero.
Well, that's not necessarily right. That's the very question here, really. I mean, which claim takes priority? Do you say, well, the matrimonial claim could never be enforced? Is the claim always got to stand behind the claim for damages, bearing in mind the nature?
Is it a matter of standing behind, or is it a matter of computation before division of assets?
It's not just computation, my lady, and perhaps I'll explain as I go along, if I may. But what we had here are two claims for two non-proprietorial claims against one and the same fund, effectively, save insofar as certain of the assets which the wife seeks are held by trusts, which the husband doesn't have automatic access to, or at the moment, pending implementation of the scheme in the draft order, he is a beneficiary, a discretionary beneficiary of those trusts. But it's not money that actually belongs to him and he could insist on having.
But presumably he was the settler.
Yeah. So that's another matter that I'll deal with the relevance of in a moment, because preventing the wife from enforcing her order prevents that part of the order being implemented, because the order requires the acceptance of all sorts of undertakings and agreements in relation to removal of the husband from any entitlement, albeit a discretionary entitlement, to those trust funds. And that, in reality, is not going to happen unless and until, first of all, the matrimonial court makes an order, and secondly, the trustees agree and obtain the blessing of courts in Jersey. And I'll refer you in due course to paragraph 33 of the draft order, which envisages that.
Sorry, I may not have picked this up, but does the worldwide freezing order also apply to the trust that you've just been describing? Very often, worldwide freezing orders these days are drafted in such a way that attempt to catch discretionary settlements associated with.
As I understand it, the worldwide asset freezing order has been served on the trustees, and one of the trust assets is a very valuable property in London, and notices have been placed on the register in relation to that property. But it's probably a matter of argument as to whether the worldwide asset freezing order actually freezes the trusts.
Okay. I mean, just since we're going from first principles to make sure we're all on the same page here, my understanding of a worldwide freezing order is that its underlying conceptual basis is that it's designed to keep in place assets against which an ultimate judgment could be enforced.
That's right.
On the basis that they belong to the defendant, and therefore would be available for a process of execution. And the reason sometimes that assets which don't appear to be legally owned by a defendant are caught by a worldwide freezing order is because the courts recognise that people often have access to or control over or beneficial interests in assets which are not in their own name, but would, by a process of enforcement, become available. That's why trusts of the offshore type or the discretionary type are sometimes made subject to a worldwide freezing order if there is evidence to suggest that the assets in those trusts might ultimately be available for a process of execution of a judgment.
Well, we would argue the assets of the trust don't actually belong to the husband, albeit the trustees could, if they chose, distribute those assets.
There may be disagreements about that.
There may be
if it's a
disagreements.
true discretionary trust, that then they may not belong and might not be available, but there are many trusts which are said to be trusts only in name and not in reality. And that seems, but that would all have to be tried out post-judgment.
And I think the bank has been threatening proceedings, although it's
the
never
bank's
actually...
been clear in the papers we have before us that they're contemplating.
Never done anything about it. What I should say does, at the moment, belong to the husband, which is, as it were, held by the trusts, is that the husband or companies of the husbands has loaned money to the trusts, and he at the moment is entitled to the repayment of those loans. And that's worth, I think, about £65 million. So the husband certainly has ownership of those funds, although part of the...
But he has ownership of a receivable owed by the trustee.
He owes the debt.
He owns
the debt.
Owed by the trustees.
Owed by the trustees to him or to his various companies. And part of the scheme of the proposed family order is that ownership of those debts should pass to the wife. Of course, it's appreciated that can't be done without the order being implemented anywhere, and that is certainly caught by the worldwide asset freezing order. No question about that. So what we had were two non-proprietorial claims against one and the same fund, the husband's assets. And indeed, albeit Mr. Marks for the bank was trying to secure a postponement of the wife's claim until after conclusion of the bank's damages claim, he was forced to acknowledge that his case in that regard would have been stronger if the bank did actually have a proprietorial claim. Can I just refer you to where that is said? That's in the supplemental appeal bundle. It's in tab 12 at page 162. You see there's a transcript with 4 pages of transcript on 1 page of the bundle. And I'm looking at internal page 32, starting at line 22, with Mr. Marks saying, "We accept, of course," and this is a point made in the last part of paragraph 44, "we accept, of course, that our position is not as strong as it would be if we had a proprietorial claim over these assets. Of course, we have to acknowledge that. We would much rather be able to say that we have a tracing claim in respect of the specific assets that the wife targets. But in financial remedy proceedings, the court's not concerned with which individual assets are required at what particular time, but it is required to have regard to all of the assets and liabilities and obligations and responsibilities of both the parties, and that's what it cannot do at the moment." Well, I'll come back to that question of have regard to, because have regard to, we submit, doesn't simply mean it's got to deduct them from the potential pot. One can have regard to a potential liability without an automatic deduction. We say, I'm ahead of myself, but we say that the court would have regard to those potential liabilities and damages by making it clear in the order that we sought, and also in any judgment given at the time that order is made, that the order isn't capable of being implemented or enforced unless and until the worldwide asset freezing order is varied or until it's discharged, and making it clear that the order which is made on the basis of the position as between the husband and wife, absent any substantive consideration of any damages that might be awarded. So it's being made clear that the pot that is being considered doesn't take any theoretical account of any damages that might be awarded. So if and when it comes to enforcement and priority of debts and such matters, the basis on which that order was made will be clear. So one can, we say, have regard to a potential obligation in that way and provide protection in that way.
Could you just help with what is the value of the claim against? You said a lot of it's damage, a lot of it's interest, but what is the claimed value of the bank's claim?
I think the last I saw it was about 4. Well, the claim itself was 1.9 billion, but with interest it's said to be about 4.6 billion.
And what are the assets of the couple?
The assets of
the marital assets that are being divided.
The marital assets, well, we don't know because there's never been actual disclosure of entirety, and of course one isn't able to put a value on things because a goodly amount of the husband's assets are held in Ukraine at the moment, so goodness knows what they're worth. But it's in the billions.
You're talking sterling, or I mean, it may not matter, but you're sterling.
Yes,
Yep.
yes, I'm talking about sterling. Yep.
Where's the statement of information in the bundle?
Where's the,
Is the statement of information in the bundle?
I
Why,
think so.
why not?
But the statement of information, it's acknowledged by the wife that whatever the assets are, they're referable to the husband's endeavours principally before.
Could copies be made available to us?
Yes, certainly.
Thank you. I mean, not this minute, Mr. Turner. You don't have to. Everyone doesn't have to start scurrying around this moment. We could happen.
No.
By the end of the day, that would
Certainly, the judge refers to it in his judgment.
understood.
Was the husband not required to disclose the whereabouts and value of his assets as part of the worldwide freezing order?
Yes, I haven't seen that, but there undoubtedly has been, and Mr. Marks has
Presumably
referred
the two
on
documents
occasion
should, in theory, be the same, shouldn't they?
to what the husband has said in response to the worldwide asset freezing order. His assets are, as I say,
Well, should those two documents not be effectively the same?
Well, I've never seen that. That's never been part of the.
Okay, in theory, should the disclosure
Yes.
of assets pursuant to a general worldwide freezing order by a defendant and the disclosure of information in matrimonial proceedings of somebody who is a defendant to his partner, wife, be the same?
Yes.
In theory.
We never got to the full stage of dealing with.
Yeah, I'm only asking in theory, so I'm not.
Yeah, yes, and ultimately one would expect it to be.
Right.
But of course, what happened here was that there was a case management hearing before Mr. Justice Peel when directions for any outstanding matters to enable his lordship to make the financial order would have been obtained and directed. As at the time the matter was before him, all that he had was there was a statement of assets and the wife's witness statement that she made. You've seen her
We've got that.
detailed witness statement. But of course, she's unable in her witness statement to set out the details of what the husband's finances are because she's never had any personal knowledge of that.
Because in theory, if a worldwide freezing order is granted for the maximum amount of the claim, the husband is in fact free to dispose of his assets as a defendant, over and above the amount of the worldwide freezing order.
Yes, but it's not thought that he's likely to have any assets
So
over and above that.
Lord Justice Dingemans' question was in part directed, I think, at trying to understand the equivalence or otherwise of the level of assets disclosed by the husband and the level of the claim against him.
I think it's thought that if the claim against him succeeds in full in damages and in interest, there will be nothing left if that was to take priority over any other obligations. And of course, what happens, one might ask, if someone else sues him and gets a judgment for damages?
Well, this goes to the potentially, as you may be saying, to the heart of what may be thought to be the heart of this case, which is it really a competition, or is it a question of what's the size of the pot to be divided in the matrimonial proceedings?
No, it's not just a question of what's the question of the pot to be decided, to be divided, but how the assets are to be divided between any damages judgment and any order that the wife has. Bearing in,
I think that may be the question, because one of the issues is whether in matrimonial proceedings, as between husband and wife, one is dividing a pot. The pot is what is available to the couple once all their debts have been paid. That's in the transcript that you just read out, that in essence, I think, is the question that was being posed there.
well, we do question whether that's actually right, because that
I think that's the nature of this may turn out to be
the issue in the case.
Heart of this appeal.
Yeah, because that assumes that a non-proprietorial claim can always take priority in reality to a matrimonial finance claim.
Well, it depends how you frame your question. You put it in terms of priorities. Somebody else may say, actually, the nature of a matrimonial claim is simply a division of a net pot.
And that's why I said I'm going to come to the question of the nature of a matrimonial claim.
We know where the battle lines are drawn.
And compare it with, I mean, what would happen if you had damages claims against the husband, ordinary civil damages claims by two entities? How would one judge between them? There's still only one pot. So there has to be some decision as to how you divide what is available between those two claimants, who may both have damages which exhaust the entirety of the assets. Why should it be different with a wife's claim?
Because, can I just put a proposition so you can see whether I've misunderstood it? My understanding or misunderstanding was that in matrimonial finance proceedings, what you're trying to do is work out what is the pot, the available assets, and then divide it. But if in truth, because of the outstanding claims, there is no pot, suppose the claim is good, and I know that's obviously strongly contested in the chancery proceedings, but if the claim is good, then in fact the husband and wife are engaged in an exercise in futility because they've got nothing to share.
If one accepts that a judgment for damages will always reduce what the wife can claim, and that really is what the question is that we're concerned with here.
Thank you.
Because certainly it can, or it should, if it's a proprietorial claim, But if it's a non-proprietorial claim, why should it why should that, as it were, be paid from the assets, from the pot, to the exclusion of the wife's claim, any more than if there were another ordinary civil claim, if someone else was claiming against the husband?
Perhaps you're going to come to this when you go. I think you've said you're going to take us back to effectively first base on this.
Sorry, my lady.
But normally you start with computation and then distribution, and actually computation. I mean, you're hanging on to the word proprietary, but I mean, if there's a big tax bill or if there's a big judgment debt where it's unsecured, you'll knock that off before you decide what's available for distribution.
Yes, but what we're
And
doing...
that's not saying you're giving preference to one claim over the wife. That's just saying what are the net assets available for distribution.
What if the wife has, as it were, what we would describe as an earned entitlement? She doesn't come to the court
I think most wives would think they've got an earned entitlement by virtue of having been married for however long, Mr. Turner.
Yeah, and that's what Miller McFarlane says. That's what Lord Nichols says, and we've.
But that doesn't stop you taking off the tax bill or the whatever other unsecured debt is outstanding.
You are then giving priority, aren't you, to a non-proprietorial claim when the wife has a perfectly valid claim herself on an earned entitlement basis, just as someone else who's suing the husband for damages. If you've got two claimants for damages against the husband, neither one of those will automatically take priority in terms of payment. The available monies will have to be distributed in some way between them. If you've got what is, as between the husband and the wife, a legitimate distribution, notional distribution of the assets as they stand at the moment, but making it clear that that distribution in the order does not take account of the damages claim, then when it comes to enforcement and implementation, you have two legitimate orders, and whoever is dealing with that question of implementation enforcement, and we say it should be the Chancery Division judge in this case, will be able to decide, taking into account all relevant matters, if it be bankruptcy proceedings, how the two orders should be dealt with. There may be, and there are threatened Section 423 of the Insolvency Act proceedings. Mr. Justice Peel expressly said that he wasn't going to be dealing with any of that. So we say, who is going to deal with it if it happens? So what we're seeking to do is actually draw an analogy, although I accept it's not a precise analogy, with a claim for damages and a claim for matrimonial finance. Because the claim for matrimonial finance, though my lady says, well, the usual route is computation, and so it is, but that's only a judicial gloss, as it were. There's nothing in the statute that says you have to do a computation. What the statute says is what's set out in Section 25. And in most situations, of course, that's what you will do. But you can take account or have regard, to use the phrase in Section 25, to any potential liabilities in a way other than, as it were, waiting until you see what that is and then deciding. And what happens if the bank does get an order for damages and interest amounting to 4.6 billion? Mr. Justice Peel says, oh, well, you can come back to me once the damages claim has been decided. What happens then? The husband and wife still say, well, we want this order approved, please. what's Mr. Justice Peel going to do about that? The husband will say, well, I appreciate I haven't got the funds to pay it if the damages claim takes priority, but I say it shouldn't. There should be a looking at both the claims to see how they should be apportioned.
Can I put I'm speaking entirely for myself. I probably would like to have a quick look at the underlying statutory powers which the court is exercising.
I'm going to take you to it, don't worry. Yep.
But I'll just put the question which follows on from the ones you've just been facing. Is another way of looking at this, not as you have put it to us, a question of competition to the same fund, but there may be two different funds involved here. One is the general fund of the husband's assets, which are available to his creditors. And the second is a net fund, which is available for division between matrimonial partners. You know, I don't know the answer to that, and that may be an entirely wrong way of looking at it. But you have made an assumption that one is dealing with competition to the same fund. And I just question at the moment if what the family courts do is to compute the net fund after debts have been paid. It's not actually competition to the same fund, is it?
Well, that's what they generally do. I readily accept that. But what I submit is it doesn't necessarily follow from the wording of the legislation that the court has to deduct from the pot when it's making a matrimonial finance order any particular part of any damages order, if the damages order has already been made. Right. And I say an analogy with that is, as I say, the confiscation of assets, because there the criminal court may have found that someone's proceeds of crime are X based on 6 years of assumed, presumed criminal activity, but it doesn't mean that the family court will then take off that entire amount. It will look to see if there's any asset which is the direct proceed of crime, and then it's a question of fairness as between the remainder. And one can say, just from looking at the head note of, we've got one of the authorities in the bundle, in the primary authorities bundle. It's the tab 16, Customs and Excise Commissioners against A and another. Two sets of proceedings. It's the Customs and Commissioners proceeding against A and the matrimonial finance proceedings A and A. And what we've done, I hope it shows up in the court's copies, is to highlight in colour rather than sideline. And it's very difficult to sideline on electronic versions, so we've taken the liberty of ignoring that requirement and highlighted, which achieves the same purpose. Just looking at the head note, the highlighted part, the judge hearing the ancillary relief application together with the commissioner's application rejected the contention that proceedings under the 1994 Act took priority over proceedings under the 1973 Act. He found that the wife had no knowledge of the husband's criminal activities, no part of the equity in the house had been acquired with the proceeds of drug trafficking, so no direct, no proprietorial claim by analogy, and exercising his discretion under Section 25 of the 1973 Act, which we'll look at in a moment, ordered that the house and policies be transferred to the wife and dismissed the commissioner's application. On appeal by the commissioner and the receiver intervening in the ancillary proceedings, held dismissing the appeal that neither the 1973 Act nor the 1984 Act, and in place of the 1984 Act read judgment for damages, for non-proprietorial damages, took priority over the other, where both were invoked in relation to the same property, and both statutes conferred discretion on the court to make orders, the exercise of which would depend on the facts of the individual case, that it was not axiomatic that it was more in the public interest to enforce a confiscation order than to make a property adjustment order, that therefore the court's jurisdiction to make a property adjustment order under the 1973 Act was not ousted, and the property in question was the subject of an application to enforce a confiscation order. So you've already got a confiscation order, which, as it were, would exceed the funds that would otherwise be available to satisfy a matrimonial finance order. So it doesn't necessarily follow that one says, well, what's the pot after you take off liabilities? Because there, the husband had liabilities. He had liability under the confiscation order. What you have to do, under Section 25, is have regard to, and shall I take, my lord and lady, to Section 25 while we're still discussing that. It's in the authorities, the main authorities bundle at tab 1. And of course the court in family proceedings has all sorts of powers to make lump sums, transfer of property orders, variation of settlement orders, maintenance orders, to readjust how properties are held. But the question is how it's to exercise those various powers.
How are those powers expressed in relation to property?
Well, it's expressed in relation to all of the powers in the same way.
No. How are the underlying powers in sections 23, 24, 24A, 24B, or 24E? How are they expressed? Is there a definition of property, for example, to which the powers relate?
There's no definition in the statute of property, but the court can transfer property from one party to another. It can make lump sum orders.
Okay, but going back to basics, is it's property of the parties to the matrimonial proceedings? Both of them, is it?
I think yes, but I don't know. We can look at that and tell your lordship.
So it's only looking at...
It must be, because it's transferring property from one party to another.
It's looking at, in balance sheet terms, it's looking at the asset side of the balance sheet, not the liability side of the balance sheet. It's
transferring property from one party to another. And until, of course, a damages claim is implemented, the wherewithal to satisfy the damages claim is still the property of the husband in this case.
So there's no. So all I'm checking is that there's no indication in the underlying sections which contain the powers that the concept of property, for example, is in any way limited to net property, i.e. assets less liabilities. It's just property, i.e. asset side of the balance sheet.
I don't think it is. I think it's simply transfer the property of one party to another. But obviously we'll check that. I see my lady has the Bible in front of her in relation to that.
Just looking at section 24.
Before you just leave customs and commissioners and A, can I just, in paragraph 11 of that judgment, the issue there was really one, did the court have power? And it wasn't ousted by that, but whether the court chooses to exercise its power is really a matter of discretion for the judge below.
Yes.
Which, I mean, rather suggests that that it does become then an issue of case management by Mr. Justice Peel, or is that wrong?
Well, case management, I don't think is something that's defined. I'm going to come to case management as a topic in itself in a moment. So if I can deal with that when I deal with case management. I would submit that that's, rather than being called case management, that's an evaluative exercise, because like all such powers, it has to be exercised in a principled way. and that's what cases such as White and White and Miller, McFarlane do, is to explain the principles on which matrimonial finance orders are made, rather than just sticking a finger in the air and saying, well, I think X would be a rather good idea. They set out principles for assessing and deciding how they're to be dealt with. Does the court have section 25 open?
Yes, thank you.
Can I just look at section 24? An order that a party to the marriage shall transfer to the other party, to any child of the family, or to such persons as may be specified in the order for the benefit of such child, such property as may be so specified, being property to which the first mentioned party is entitled, either in possession or in reversion.
So it's looking at the asset side of a balance sheet only.
So it's only looking at the asset side of the balance sheet. But section 25 is broader than that. Headed matters to which the court is to have regard in deciding how to exercise its powers under the various sections that provide the powers to make substantive orders. It shall be the duty of the court in deciding whether to exercise its powers under those substantive sections, and if so, in what manner, to have regard to all the circumstances of the case, first consideration being given to the welfare of a minor, to the welfare of a minor child of the family who has not attained the age of 18. And then the passage that Mr. Marks has drawn attention to is section 25(2). As regards the exercise of the powers of the court under the substantive sections, in relation to a party to the marriage, the court shall in particular have regard to the following matters. And one of those matters is B, the financial needs, obligations and responsibilities which each of the parties to the marriage has or is likely to have in the foreseeable future.
Sorry, Mr. Chair, I'm sorry if I'm throwing a curveball at you.
Sorry, Malin.
I'm sorry if I'm throwing a curveball at you, but in Sharman, the Court of Appeal, that's where you go first for your computation and then distribution. That's where we all got that sort of phrase from. I don't.
It's quoted.
Sharman's not in the bundle.
It's not in the bundle, but it's quoted by the judge below.
Yes, but is there anything else in Sharman that goes further about? I can't remember, to be honest. About how you compute the computation. Again,
I don't think so, but I can't put my hand on my heart and say there isn't. But of course, obligations can cover a multitude of things. It can cover obligations in the terms of, if you're looking at traditional roles, if you're looking at obligations that one party is likely to have in the future, paying a mortgage or whatever.
But Sharman said the first thing you do is look at the financial position of the parties. So arguably, the financial position of the parties is, if the bank succeed, there's going to be no money. And if the bank don't succeed, then this looks like a pretty fair outcome.
Yeah. Save, of course, that on the confiscation case, which demonstrates it's not just a question of looking at liabilities in terms of looking at orders that have been obtained elsewhere.
But that was approving a judge at first instance decision to transfer the extra bit of the house in which the wife was living with two dependent children, in circumstances where she had an absolute right to at least half the house, which is a million miles away from giving £100 million transfer in the face of a $5 billion claim.
Yes, well, of course it is, and I don't suggest for a moment that if this order is made on the basis that's clearly set out in the draft order, and if there's an order for 4.6 million in damages and interest, that when it comes to implementation and enforcement, it would follow that the wife would get enforced what she's seeking there. All that that order will be doing was saying, as between the husband and wife, as things stand at present, without taking into account any damages that might be ordered against the husband in the future, this would be a fair order, and we would have been able to explain, we suggest to Mr. Justice Peel, why it would have been a fair order as between the husband and the wife. But, as said in the face of the order, it's not to be implemented or enforced without permission of the commercial court judge,
Chancery.
which it couldn't be anyway because of the worldwide asset freezing order.
But you could apply to vary the freezing order, and I think at first instance you said that was your intention.
Well, we didn't say that at all. That's why
Well, that was
the judges said we did. But if you look at the wife's witness statement, it didn't say that. It's an option, but we certainly didn't say that was our
Have you
primary
given an
intention.
undertaking not to?
Sorry?
Have you given an undertaking not to?
We haven't, because we'd like to keep our options open. But if needs be, if that be the price of success or failure, then yes, because realistically, it's not terribly likely to succeed, is it?
That doesn't stop people spending a lot of court time doing these things.
It's
And that's why I put to you that it was case management.
Lord, if it was a question of that being the be-all and the end-all, but of course, if one went to Mr. Justice Trower, who's very, very familiar with the case below, I think he's made about 60 orders so far in the
Poor man.
in the damages proceedings. If one went to him and said, well, you know that worldwide asset freezing order, Judge, will you please release 110,000 or whatever to the wife, he's going to want to know a great deal about that, more than just, well, she's got a matrimonial finance order, particularly where the matrimonial finance order makes it clear that it's not to be enforced without that permission, where it's made clear that it's not seeking in any way to tie the hands of the judge in the commercial court, and where it will be absolutely clear that it was made without any account being taken of the claim for damages, other than it being taken into account by reason of the making of those conditions. And that's where I turn back to section 25(2)(b). The financial needs, obligations and responsibilities which each of the parties to the marriage has or is likely to have in the foreseeable future.
Why people skipped over 25(2)(a)? I mean that.
Well, exactly the same goes, which.
Well, it also, just reading along, requires the court to have regard to the property that each of the parties is likely to have in the foreseeable future. If you know that, for example, a husband faces a large damages claim which he'll have to meet, his property will foreseeably be reduced. I mean,
my point is that whichever subparagraph of this subsection one looks at, all the court is required to do is to have regard, not to just take it off the top and treat the available assets as a sum after deduction of that sum. Of course, you can't do that in relation to obligations which each of the parties of the marriage is likely to have in the foreseeable future. What you can do is have regard to it by making clear those things that we've suggested should appear in the order of which we sought approval. You have regard to it so that that order isn't enforceable, come what may, and it's known to those who have to deal with how the totality of the pot is to be distributed, that it was made on a particular basis.
But one of the things the court will have regard to is that the husband faces the claim for amongst others, that the claim for did you say 6 or 8 billion pounds, and that the court has already held that the case against him demonstrates an elaborate fraud perpetrated by someone money laundering on a vast scale, and a good arguable case of fraud on an epic scale. That's the quote we were given from the Chancery judgment.
Yep.
So the court at first instance, in being asked to approve an order for £100 million in favour of the wife, it can't just ignore.
No, it can't, and that's why.
But you're saying they should set it aside.
No, and
This
that's...
isn't a kind of speculative
No.
risk.
I'm certainly not asking that the court at first instance and the family court should ignore it. I'm saying that the court should have regard to it, and the regard it should have to it is to approve an order which, if it was just between the husband and the wife, based on the assets and the facts as they exist at the moment, this would be an appropriate order. But the court can't tell what's going to happen in the future about that claim, the damages, or how that should interact with any order that the family court might make. So it makes it conditional in the sense it's not enforceable without permission from the commercial court that knows all the details of that. It is clear that it is not an order which is made having taken account of the of 4.6 billion or any other sum that might be awarded in damages, and it is made on the basis that the best court to decide what should happen about the competing orders, if there be competing orders, because, you know, however strong a case may seem, I think it was Mr. Justice Sedley or Lord Justice Sedley who once said, you know, things always seem very strong until you've tried them out. This isn't the first claim against the husband in commercial courts. I think there have been 3 now reported, and in one of the others there was Mr. Justice Barling, who investigated the question of whether the separation agreement between the husband and wife was a sham, and he concluded it wasn't a sham. And there's a transcript available of the judgment of Mr. Justice Barling dealing with that.
Can I just question whether the proposition that it's for the Chancery Division to undertake that task is right? Why is it right? All the Chancery Division is going to be doing is to determine whether the husband is liable to the bank. That's it. It will give a judgment, yay or nay, or somewhere in between. And that's it.
Yes.
The Chancery judge isn't in that trial interested in rival claims.
No, not in that trial.
No, I mean, there then may follow either processes of execution on a judgment,
Yes.
or bankruptcy proceedings against the defendant if there's been a judgment against him. But that's another court in another context.
But the ideal court to deal with that would be the court that's dealt with the damages claim. But your Lordship's absolutely right. Perhaps I should have said that the court dealing with implementation or bankruptcy of the damages claim, because one will then...
Well, because to be fair, Mr. Justice Farrell probably has enough on his plate trying the action without having some family question put on his shoulders as well.
Well, is it then going to go back to Mr. Justice Peel, who knows nothing about the other proceedings, and ask him to deal with any questions of...
Doesn't it then depend upon the question of which fund you are administering?
Yes. Well,
You see,
Mr.
because
Justice...
if subsequently there are bankruptcy proceedings, the bankruptcy judge will have the responsibility for determining which claims lie to the fund which the trustee in bankruptcy has control over. Whereas if it's different, the family judge will have responsibility for making orders under the family jurisdiction in relation to such fund as the family courts are concerned with. And it goes back to this question of who's administering what fund. And I understand there may be arguments for two judges, as it were, to have some sort of understanding of what the other is doing, if not actually liaising on the
And
case.
what's going to happen if the matter then, if there's an order for 4.6 billion against the husband or whatever in the damages claim, but the matter still goes back to Mr. Justice Peel, and we persuade him that that doesn't necessarily mean you've got to have regard to that, but it doesn't mean for all sorts of reasons that should be taken off the top, and he makes an order, not necessarily the order that we're seeking now, but an order in favour of the wife, as the judge did in the Commissioners of Customs and Excise against A case. What then happens about implementation? It still has to go to, if there's a bankruptcy, if both parties try to enforce their orders, there's not going to be enough to enforce them against. So what would happen there? You still end up in front of a bankruptcy court. The ideal thing is to have one court, one judge, dealing with all matters in relation to implementation and enforcement, saying that, well, as between the husband and Privat Bank, it may be that there are damages properly ordered of however many billions. As between the husband and the wife, leaving out of account that prospective claim, there is properly ordered whatever there is in our order, comes something in value just over 100 million, I think. How do you deal with that, and who deals with that? Now, I don't know if the court's looked at the case Mr. Marks produced more recently of George and George, which is in the supplemental authorities bundle. But I mean, I don't know if there's anything else we need to look at on section 25 with have regard to, because there's no help given on what have regard to actually means. But it certainly doesn't say if there's a debt, you have to take it off the top, let alone if there's the possibility of a debt, because that's all it is at the moment, the possibility of a debt. Now, George and George was a case where there were financial relief proceedings in the family court, and there was an issue as to whether the husband owed a debt to a Swiss trust. The judge who heard those proceedings concluded that there was no such debt, having refused to adjourn. And then in the separate proceedings, it was found that there was, in fact, a debt to the Swiss trust. So the order had been made, the family proceedings order had been made on an incorrect basis. It had assumed that the husband had got $500,000 more than he actually had, which made a very significant difference in the numbers on that case. What you have to bear in mind in this case is what it's talking about is where the original order has been made on an incorrect basis, believing that there is no such debt elsewhere. That's a very different situation to our situation, where the order would not be made in favour of the wife on the basis that there was no debt to the bank, but we made on the basis that there may or may not be a debt to the bank. But the order that's made in the family court will not be enforceable or capable of implementation without either permission from the commercial judge, so that would definitely be Mr. Justice Trower, if anyone sought to do that, or if the proceedings against the husband by the bank were dismissed, and furthermore, made on the basis that that was as between the husband and wife and took no account of the potential order for damages, and that the husband was content with that. So the order would not be made on a false basis.
May I ask a question?
Of course.
About that, which is it not making an order, because the court has a role under the Radmacher jurisdiction, is it not making it on a false basis if the husband assumes he's going to win fine, he may or may not, but if actually properly analysed after the chancery proceedings, instead of being worth billions, he's worth nothing?
Well,
wouldn't that then be an order made on a false basis or approved on a false basis?
well, we'll have to ask Mr. Howard about that, because that's a point that he's made representations about in the past, because he makes clear that the husband is very well aware of the risks. He's a sophisticated businessman, and he is prepared and indeed wants this order made, and it cannot be said later, if there's an order for damages against him, it can't be said that he's entitled to then go to the court, the family court, and say, oh, well, I didn't appreciate there was a possibility of this 4.6 billion order being made against me, even if there's anything left over to argue about.
But it's also the credibility of court orders. And if, in fact, in truth, he's got nothing to give away, and the family division is approving an order for a transfer of 100 million, I mean, it's an exercise in absurdities.
Well, we're back to that question of, does the fact that there is a damages order, if there be a damages order in the future, does that automatically come out of the pot when the court is making its order in the family court? And that's where an important issue lies in this case. Can the court only have regard to that potential obligation by waiting to see whether it comes to pass or not, whether it crystallizes, or can it have regard to it in other ways, as long as it's satisfied that there is no undue prejudice to the bank?
I mean, you will at some point get, presumably, to paragraph 14 of George and George, which I assume is...
Paragraph
14 is the paragraph that I assume you're going to have to deal with.
of George and George.
Of George and George. Yeah. But if I may just for a moment pick up something you said just a minute ago. Why would a husband facing a large damages claim which would effectively wipe out his assets agree to a distribution of property on the footing that he will be maintaining he's innocent, but there's a risk he may be found liable? And in essence, he would be agreeing to pay a sum to his wife based upon an assumption that he wouldn't be liable in the other proceedings.
But it's not...
Without the right to come back and... I mean, why on earth would you do that? Because you'd end up having to pay off the judgment debt and being unable to come back to the family court and say, actually, I was found liable, I don't have any assets to meet this agreement we've reached. Why would a person do that?
But he's not assuming, is he, that that there won't be an order against him for damages. He's got to assume that there may well be an order against him for damages. But as things stand at the moment, he acknowledges that the wife, as between him and her, should have what's in the order. Indeed, that's what was agreed in the separation agreement as well. He appreciates that if an order for damages is made, he's going to be wiped out financially anyway.
Yes, but strange enough, not as against his wife, because his wife's claim under the order would survive his bankruptcy.
Well, quite, he'd rather the wife have it than being...
Well, no. He will be wiped out as against the claimant in the other proceedings in relation to his current assets, But his wife's claim, to the extent it's not met, will survive and will continue to bind him in relation to his post-bankruptcy assets. Why would you do that?
If, as I say, we'll have to ask Mr. Howard about that, but he told the court below that that was something the husband had considered and was very happy, indeed keen to have done. I can't tell you what the husband does, because the husband and wife are not actually as close as Mr. Marks might suggest.
Okay, but I'm trying to put this on a hypothetical rather than in relation to the specific facts of this case. But if we postulate a husband facing a claim which would wipe him out,
yes,
as we've been saying, I would take all material parts of the matrimonial assets, assume the husband has been the earner, has built up assets in his own name, that's the pot. A husband who said, well, I will agree a division based upon, or any sort of large order in favour of my wife based upon an assumption that I'm not going to be made liable, but running the risk of being made liable and wiped out, leaves the husband, first of all, wiped out as against the creditor, and then secondly, continuing to be liable.
So anything he makes in the future,
as
after he's freed from any bankruptcy.
And at the moment, I can't understand why that would be fair to the husband, or realistic, and why, whether you call it a risk of false assumption or otherwise, however you characterise what the court's doing, why the answer might not be given by paragraph 14, which is, why don't you wait and see to avoid all these complications?
Well, there are two things that Mr. Justice Peel said below about fairness. He said to make this order that we seek now might not be fair to the husband, although the husband himself is saying, I want the order made. I'm fully aware of the risks. I want the order made. And one usually in a Zidias situation is looking to protect the financially weaker party, not to protect the businessman who's well aware of the risks. So one of the things we've said that Mr. Justice Peel took wrongly into account was the need to protect the husband who didn't want protecting. And the second is the question of what is the prejudice to the bank? But that's an important point. I'll come back to deal with that separately.
But would you accept that if what had come in front of Mr. Justice Peel was the financial remedy proceedings, which he was seized of, but that there was no agreement, that the inevitable and proper course would have been for him to adjourn it till after the conclusion of the fraud proceedings?
If the husband was not consenting to it, then that's probably right, because the husband would say, well, you know, how do we deal with this when I may have nothing?
You need to know what there is before you make an order.
Yes, except that that's probably right.
Yep.
But that wouldn't be based on any prejudice or potential prejudice to the bank. It would be based on potential prejudice to the husband, as my lord has explained. The husband's potential prejudice would be that although he's wiped out by the order of the bank, the wife's claim survives any bankruptcy, so anything he makes in the future goes to her, and he's got to rebuild very substantially after that. But try to deal with paragraph 14, which has been highlighted. Lord Justice Thorpe said, easy with hindsight to perceive where this case has gone wrong. And the case being, we remind ourselves, where the family court had concluded there was no debt, whereas a civil court had found there was a debt. But that's not what we're doing here. We're not concluding or assuming that there will be no debt, no damages. There may or may not be an order for damages. What we've got to do is to have regard to the possibility there may be an order for damages. And that's what wasn't done in the George case. There wasn't, for example, a contingent order, as there could have been, making clear that the order would be different, or there would be a repayment of some sort, or reverse contingent lump sum, if there was a finding made against the husband. So Lord Justice said, not right for the judge in ancillary proceedings to anticipate or to forecast the outcome of related proceeding in another division. We're not asking the family court to do that, to anticipate or forecast, when the risk of a false assumption can be eliminated either by adjourning the ancillary relief application. Well, here, yes, I accept, it can be, but you're still left with the problem of what do you do about the family division claim, because if the husband and wife still want that order made in those terms, but in any event, there are also problems, prejudices that the wife faces in the meantime while waiting for that to happen. And we'll come back to deal with those. Those are all things like what happens if the husband dies in the meantime, and at least if she's got an order that's approved now, it becomes enforceable straight away if and when the damages claim is dismissed. Or by ensuring that both sets of proceedings are allocated to the same judge, or alternatively prepared and dispatched in tandem. And one can add to that, because those are just ways that Lord Justice thought was suggesting the Gordian knot might be cut in the particular circumstances there. But an equally effective way of doing it, in my submission, would be to do what we have suggested, which is to make it clear that the family order is not made on a false basis. It's made appreciating that there may or not be an order for damages, making sure that the order is not enforceable until either there's a specific variation by the commercial judge of the worldwide asset freezing order, and making it clear that that order is made without taking into account in the numbers any order for damages, let alone a potential 4.6 order for damages, but it's taken into account nevertheless. So it's when it comes to enforceability and implementation that the matter comes to be dealt with. So we say there's another way of taking account of the matter without causing the other ancillary prejudices to the wife. Because in one sense, well, yes, the wife could wait and see what happens. If she couldn't enforce her order in any event, then why is she any worse off having to wait? Well, she's worse off because, for example, the husband may die in the meantime, and those other factors that we've set out. But Lord Justice thought in paragraph 15 says it may be consideration should be given, perhaps by the ancillary working group, to ensuring contracts is established. Well, I'm not aware that it ever has been. But there, I repeat again, it was about an order being made on a false basis, which wouldn't be the case here, and it was about protecting the husband, which is not the situation here because the husband isn't asking for protection and knows full well what the risks are. So the judge, going back to the history, acceded to the application by the bank and in fact adjourned the application for approval of the draft order until the conclusion of the civil proceedings. Mr. Marks has pointed out that under the terms of the order, the consequential order that was made, the husband and the wife could apply in the meantime, in fact, to ask the judge for reconsideration of it. But that's a little artificial because unless there'd been some change, the judge is not going to make any different order. And we can see what the view of the judge as to what he thought he was doing in practice, because that's clear from his judgment on costs. We look at the core bundle at tab 9. sorry, tab 8, page 64, paragraph 2. In the 5th line, in the context of dealing with the question of costs, His Lordship said, "It seems to me that, put simply, the bank applied for, in substance, deferral of the making of the consent order until after the Chancery proceedings, and it was successful." So that's the reality of what the order was. I mean, what we would seek to do is to go back in front of Mr. Justice Peel and explain how, if one leaves out of account potential damages, albeit making it clear that the order is made without taking account of such damages, and with all the protections for the bank, that this, as between the husband and wife, is a proper and fair order. So the wife sought to appeal, and Lady Justice King, having considered the written representations on behalf of each party, granted permission to appeal, notwithstanding that this was a case management decision. And Your Ladyship said that because Mr. Marks, in his opposition to the application for permission to appeal, had made much of an argument that this had merely been a case management order or decision made by Mr. Justice Peel. So let me get the question of case management and its significance out of the way, because Mr. Marks continues to pursue that point about case management in his skeleton argument on the substantive appeal. He contends that the decision adjourning the application for approval of the draft financial order until the conclusion of the Chancery proceedings was merely a case management order, with the consequence, he seems to suggest, that some stiffer test applies to allowing an appeal than in relation to any other sort of appeal proceedings. 4 points. First of all, when one appreciates the consequence or the potential consequences of the adjournment, it's hardly a matter of mere case management. On the bank's case, if it succeeds in its damages claim, there are going to be no assets left to justify any financial ancillary relief order in favour of the wife. So it's rather more than mere case management, or potentially. Secondly, it's right to say that special mention is made of case management decisions in Practice Direction 52A concerning application for permission to appeal. And can I just take you to that, which is in the supplemental authorities at tab 23. What page is it? 389, yes. Or is it 398?
389.
389, thank you. Sorry, the numbering's different on the electronic version. Thank you. I'm borrowing the stuff. Where an application is for permission to appeal from a case management decision, so this is permission to appeal stage, the court dealing the application may take into account whether A, the issue is of sufficient significance to justify the cost of an appeal. We suggest this one certainly was of sufficient significance. B, the procedural consequences of an appeal outweigh the significance of the case management decision. It would be more convenient to determine the issue at or after trial. Well, of course, there isn't going to be any trial until whoever knows when. So we say, milady, rightly concluded that whether it be properly described as case management or not, permission to appeal should be granted. And we see there at the bottom of that practice direction paragraph, case management decisions include decisions made under Rules 3.12 and decisions about disclosure, filing of witness statements or experts' reports, directions about timetable of the claim, adding a party security for costs. Well, none of those are remotely what this case was in substance about. If one is looking at the question of, is there some special rule or some special test for case management decisions on substantive appeals, if this is properly described as a case management decision, if we look at the next tab, tab 24 in the supplemental bundle, and we find that the test under CPR Rule 52.21 brackets 3 is that the appeal court will allow an appeal where the decision of the lower court was A, wrong, or B, unjust because of a serious procedure or other irregularity in the proceedings in the lower court. So there's no special test being said about case management decisions.
Is there anything in the family proceeding rules? I know there's a family proceeding rules that reduces the time for appealing in case management decisions. Isn't there a family proceeding rules that reduce it? Is it 7 days, 5 days, 7? Seven
Yeah.
days. There's nothing more substantive in the family proceeding rules than that, is that we have to turn to the CPR.
Well, it's the CPR that governs appeals to the Court of Appeal.
Understood.
The FPR only governs proceedings.
But you're
appeals at a lower level.
Understood, but you're talking also about the general impact of the fact that this was a case management decision, which Mr. Marks places a great deal more emphasis upon than you do.
Yeah.
I was just
Certainly
wondering
on
whether the family
appeals
proceedings rules assisted us, other than abbreviating the time that you, which is logical. Obviously, it's a case management. If it's a case management decision, you don't want to derail the trial, so that's why there's a shorter.
No. But of course, that would be covered by the practice direction that we just looked at.
Yep.
Is it proportionate to derail the trial?
Yep.
Well, that's not
Right.
the situation. But once you've got over the permission to appeal point, there isn't any separate case management test for allowing appeals. But in any event, the authority that Mr. Marks refers to in the main bundle of authorities, and it's one of many authorities to the same effect. Tab 14, page 188. Paragraph 23 of the judgment, I think it's of Justice Jackson, Peter Jackson. And what he says halfway through that highlighted paragraph is, the reasoned case management choice of a judge who approaches the law correctly and takes all relevant factors into account will be upheld on appeal unless it has been shown that something has gone badly wrong with the balancing exercise. In effect, it's the conventional test. If the judge has failed to take something into account, something relevant into account, if the judge has taken into account something that's irrelevant or reached a decision that's plainly wrong or misinterpreted the law, then the appeal will be allowed. It's not allowed in any proceedings unless one can satisfy that test. So there's nothing special about this sort of decision. But it's not, as I say, a case management decision in the conventional sense, because it has very substantial potential repercussions one way or the other. Going back to the question of what the actual fundamental issues are and were at first instance, can I take you to a transcript of the case management hearing, which is in the supplemental appeal bundle at tab 10, page 144. And this arose in the context of questions about this was a hearing in March, case management, and the question that arose was whether it's going to be necessary to file any further evidence dealing with questions such as whether the husband and wife were in some sort of improper league together, whether their supposed separation was a sham, anything of that sort, about joinder, and that letter F, Mr. Justice Peel had been expressing the view that he didn't see any need to file any further evidence. And I'd said, well, certainly I'm not asking to, because the issues, as I understand them, are really issues of law and principle. In a sense, they boil down to, would the wife be prejudiced by a stay? Would the bank be prejudiced unfairly by a conditional order? And Mr. Justice Peel said, yes, well, I tend to agree. So that's what we were dealing with in reality in the proceedings. And I suppose a question that also arises is as to, when considering whether to approve a particular draft financial remedies order in particular circumstances, what significance is properly to be attached to an extant claim for damages, in this case the extant claim for damages by a bank. But that won't be a general solution that's referable to all cases. For example, George and George, the answer was very different. But the overall answer may be you've got to have regard to it. And the case of the husband and wife was that a stay or adjournment, call it what you will, was unnecessary, and it potentially prejudiced the wife unfairly and unnecessarily, whereas the making of the order that the husband and wife sought would cause no actual prejudice to the bank. And time after time, there was the question of what prejudice there would be to the bank. And all we ever really seemed to get was, well, the prejudice was that the husband and or wife might go off to the commercial court judge and say, look, we've got this order and it is approved by the family court judge, and therefore it is enforceable and you should vary the order on the strength of that. But we say that's just unrealistic to think that that would happen, quite apart from the fact the order itself, or the proposed order, makes clear that that's not the basis on which the order is made. The idea that the bank would ever allow an application on that basis to go ahead without correction is incredible. So what is the potential problem for the bank in doing this? Of course, what the bank wants to do is to strengthen its case, to get an order for damages on a non-proprietorial claim, and it wants to then say, well, there's nothing in the pot for financial proceedings, So everything goes to the bank. But we say the bank can be fairly protected in the way we propose, but the wife, whatever the rights and wrongs of the academic arguments are, the wife can't be fully protected, and there is some risk to her, whereas there is no risk to the bank if this order is not made. I said I was going to talk about the nature of a matrimonial finance order. Can I go to the main authorities bundle at tab 11, page 56, which is the House of Lords decision in Miller-McFarlane. And what I want to look at, and that Milady will certainly be very familiar with the Miller-McFarlane case. I want to look at what Lord Nichols said in paragraph 9 of his speech in the House of Lords. And that's page 69 of the bundle, paragraph 9 onwards. He said, "The starting point is surely not controversial. In the search for a fair outcome, it is pertinent to have in mind that fairness generates obligations as well as rights. The financial provision made on divorce by one party for the other, still typically the wife, is not in the nature of largesse. It's not a case of taking away from one party and giving to the other property which belongs to the former. The claimant is not a supplicant. Each party to a marriage is entitled to a fair share of the available property." And I appreciate available property is a phrase
That's a bit of a tricky one for you, Mr. Turner.
Well, I say it's not, because at the moment it is available. And if you're saying...
it's not, because it's subject to the adjournment.
Yes, but if you make the order subject to caveats which mean you can't enforce it without more, then it is. And of course, I don't think what Lord Nichols was saying there was within mind what the situation we're looking at here, and what he and what the other members of the court went on to do in Miller, McFarlane, was to set up principles by which this entitlement was to be assessed, fleshing out, as it were, to some extent, what's not said in the actual statute about how the court deals with these claims. But what he was making clear in that paragraph 9 was this isn't some sort of largesse or beneficial order, it's an earned entitlement, earned by the years of marriage, earned by the contribution to family life, earned by standing by the husband at the time when he's earning the money himself, the marital bequest.
I think bringing up 4 children on her own might do it.
Yes. So,
is it also subject to the liabilities which the parties to the marriage have incurred to third parties during the course of the marriage?
Yes, it may be, but not necessarily, as we know from the A and Commission of Customs and Excise. But of course here, we're not saying the wife will necessarily get this. All we're saying is there should be this order which reflects the position fairly as between the husband and the wife, without taking account in numbers terms, because you can't, of the claim for damages, but taking account of the existence of the claim for damages. Indeed, I could take you through the draft order and show that it's spelled out in terms, in recitals, that there is a claim for damages against the husband by a private bank. It's referred to in terms in various places in the draft order, quite apart from what we've called the conditionality terms at paragraph 48 onwards. And then there is reference in umpteen of the other paragraphs to on satisfaction of the conditionality terms. So what it's purporting to do is no more than say this is fair between the husband and the wife as things stand at present, but we have regard to the fact the wife may not actually get that. It depends. Now, so both parties, the wife and private bank, must be protected, and we submit that our proposal was the fairest way to provide the wife and private bank with protection. Because if the bank's claim failed, then the wife could enforce immediately without further ado. If the bank's claim succeeded, then there would be further processes, as there would inevitably have to be, unless one accepts that, well, that's it. A claim of this sort, a damages claim, a non-proprietorial claim, outweighs the non-proprietorial claim of a bank, of a wife. That's what I'm saying. Her claim is, as it were, just as good as a claim in contract or a claim in tort by her. So why should one necessarily take off from that in its entirety any damages that are awarded against the husband? Why should she be treated differently than if she was an ordinary civil claimant with a judgment against the husband? It might or not be enforceable in full, but it shouldn't be accorded some lesser priority.
Well, is it part of that? Because the rival civil claim won't have been determined by reference to the quotes available property unquotes of the marriage. It would be an independent claim.
But available property, as I say, is a phrase used in the course of a speech which isn't dealing with this express problem, so it's not considering this express problem. And as at the time the order is made, this is available property, but one is having regard also to the possibility that there may be an obligation in the future, and one fairly protects the bank by having regard to that, by not making that order enforceable.
But would the order be revised in light of the bank's judgment?
Well,
if the bank gets one.
It's a
I know
question
you
of
say it
whether
can't be enforced. But
it would be a question of whether it wouldn't be revised. It would be a question of how much, if any, of it could be enforced, not any revision of the order as such. The order as such would still stand.
So we go back to the same question: what's the purpose of the orders? Because what the order then does is create a rival claimant in the husband's ultimate bankruptcy to the bank.
Yes.
And it goes back to the question about whether it's appropriate, therefore, to do that in matrimonial proceedings.
Well, it's got a number of purposes, hasn't it? It's got the purpose that it leaves the wife able to argue within the enforcement proceedings that she is a creditor who ought to receive that money. The bank can then counter that with Section 423 applications or whatever. So it provides her with that potential benefit. It is no...
But the Section 423 proceedings could go behind a court order.
Sorry, Section 423 would set aside the court order, wouldn't it? Potentially. Section 423 is tab 3.
I know Section 423. I'm pretty familiar
Your
with
Lordship will be much more familiar with insolvency law than I am, of course. Although it's Section 423 is something that has been appearing more and more in family law cases.
Yeah. I mean, the traditional, or the conventional use of 423 is to set aside a gratuitous disposition from one partner to another, which is designed to frustrate people bringing a claim against. I mean, let's say a husband gives an asset to a wife.
Well,
It
my Lord,
could be the other way round, but with a view to ensuring that the creditors who ultimately come knocking at the door are go away empty-handed.
because
But
it's
it's
Mr. Marks
not a
and bank
disposition.
who
It's not a disposition which is normally done with the imprimatur of a court order.
it's Mr. Marks and the bank who keep threatening Section 423.
Yes, but so put it in a slightly different way.
Yeah.
If I was a judge being asked to validate a disposal of assets, and I was aware that it might be a disposition which was capable of Section 423 challenge, I think I'd be pretty wary about making the order in the first place. The trouble with court orders is they tend to be proof against
Yes, but
claims.
Mr. Justice Peel had made it clear that he wasn't going to be dealing with any arguments about Section 423, so it couldn't be dealt with in front of him.
So the concept, is this right, is that if the order is made, if the consent order is made, that Section 423 proceedings could still be launched, or should still be launched, to set aside the court order. Is that the way it would work?
Well, I would want to reserve the right to be able to argue that one couldn't do that.
I bet you would.
So I'm certainly not going to concede it here and now. Sorry, Mr. Well, the judge certainly, and I can refer you in a moment to the passages where he made clear that he wasn't going to be dealing with any Section 423 application.
No, I appreciate it. He didn't think he was dealing with a Section 423 application because none had been made. But it's not quite the question I think I'm posing. The question I'm posing is whether if the court made a consent order now, it could be undone at a later stage by an application under Section 423. I'm not aware of an authority that has used Section... I certainly don't claim to know every Section 423 case, but I'm not aware of one that actually has been used to set aside a court order.
Well, I would obviously want to argue that it couldn't be, but the question really then is one about enforcement, not Section 423. Because if you've got a limited fund and you've got a number of judgments against that limited fund, it's who gets what.
You see, I understand entirely the situation where you have two rival civil claimants.
And I'm saying this is analogous to that.
Well, that's the question.
Yes.
If you had two rival civil claimants, of course, in a bankruptcy, they both prove pari passu. They prove a new rank pari passu. Because they've both been independently determined. You know, one's a tort claim, one's a contract claim, let's say, by, let's say, a husband who's committed a tort in the course of his life and has broken a contract. Everybody understands that's competition against the same fund between two third-party claimants. But neither of the orders in those cases has taken into account what his assets are. Whereas the order under the matrimonial legislation does require a different set of factors to be taken into account.
Not to the same extent now, because since Radmacher, although the court still has a duty under the statutory power section, was it 39, section 33A, to independently scrutinise an order, and it has to consider the information which is put before it. Section 33A, sorry. It has the power under Section 33A to make a financial remedy order in agreed terms, which was what we were asking the court to do. But it was not bound to make the order without further inquiry. And we've got Section 33A in the supplemental bundle at tab 22. Supplemental bundle of authorities. And there are many authorities which show that one is not making the order on the basis of the contract as such, and the order derives it, and the order derives its force from what the court does rather than what the parties have agreed in terms of contract. But Radmacher muddies the waters a little bit about that nowadays, because Radmacher and Granatino, which in the authority is at tab 13, although I'm not going to refer to any particular part of it, is the Supreme Court case where it was decided, and I paraphrase, that an agreement between the parties for a financial remedies order, whether it be a prenuptial agreement or a postnuptial agreement or a separation agreement, because that's what we're effectively dealing with here, is presumptively binding on those parties. Now, there are exceptions, but those exceptions are where one party then seeks to resile from the agreement and says, for example, well, it was unfair to me, I was put under improper pressure, I didn't really agree, one of those sort of things. But nothing of that sort happens here. There's nothing that the bank can pray and aid in relation to that. So we say presumptively binding.
Why does that muddy the waters?
Why does what, sorry, ma'am?
Why does it muddy the waters? Because Radmacher, I can't remember, is it 70-something in Radmacher?
75.
Is it? Thank you. I knew it was 70-something. I mean, if it's not, if the court thinks there's a problem with it or it's not fair, then the court doesn't have to make
Yes.
it. I mean, it's not
Well, the
binding
court-
on the court, so the court's oversight still applies.
Yeah, the court's oversight still applies under Section 33A of the Matrimonial Causes Act, but Radmacher sets out the principles on which that oversight will apply. So the court's not concerned with a scrutiny of the detail of matters of this sort. But in any event, what we wanted to do and what we were prepared, ready, willing and able to do was to explain to Mr. Justice Peel why, absent an award of damages against the husband, the order that we sought was a perfectly appropriate and fair order.
Well, why could the judge not say, yep, I think if he's worth however many billions, 100 million, 4 children, marriage this length, etc., is a very fair order. I'm content with that. However, it's not an order that reflects the reality of the situation, because the computation's not being done, because this huge outstanding claim, which we know is not a hopeless claim, because we've seen the judgment in the Chancery proceedings. And so therefore, whilst ultimately, if this claim is dismissed or hugely ameliorated, then this would be a Radmacher order, which I'm very pleased to approve. But I can't approve it at the moment because it bears no reflection to reality. What would be wrong with that?
What would be wrong with that would be that it would cause certain prejudice to the wife, and it would cause no prejudice to the husband that he's concerned about. And insofar as one takes account of the interests of the bank who are already protected by a worldwide asset freezing order, it creates no prejudice to the bank.
Well, it does, doesn't it? Because you've said you're then going to turn up in front of the insolvency judge and say, look, 100 million plays 4.5 billion, prorate it, etc. Whereas we all know that the order was made on a wholly false basis because there wasn't the 5 billion to split.
I think I said no legitimate prejudice. And of course, that's not a prejudice that the bank has prayed. When the bank's been put on the spot and asked what the prejudice is, and if you look at the transcript, it simply says through Mr. Marks, well, they might go along, and indeed he said they're planning on going along, and but not if you look at paragraph 9 of the wife's witness statement. I appreciate Mr. Marks didn't have the wife's witness statement at the time he was making those submissions. That's not what the wife says at all. Indeed, from a practical point of view, it would be a rather hopeless endeavour unless there's been some significant change in the meantime.
The target's wrong, but the point that my Lord has just put to you must be the right one. It may be that they would be wasting their time, or you'd be wasting your time to go to Mr. Justice Trower who is in the middle of a big trial and say, look, actually, can you just allow or vary the worldwide freezing order to allow this division of property? I mean, that's the wrong target. The target that would prejudice the bank is when you turn up with, or wife turns up with order in the bankruptcy that may follow a successful judgment in favour of the bank after the Chancery Division proceedings have concluded.
Yeah. But the basis on which the order has been made is clear. That's my point. So we come back to that again.
So are you saying that the order makes clear that it would not bind any bankruptcy court? It would not be provable in the bankruptcy, or that it would not bind the bankruptcy? And how would that work? The bankruptcy, the trustee in bankruptcy would have the right to reopen the family division order, or would be challenged in the bankruptcy.
Isn't there the power for a
proceeding?
trustee in bankruptcy to apply to reopen family orders?
So you tell me.
There certainly was at one time.
But I'm.
But what all that the order is doing is making clear what the fair solution is, as between the husband and the wife, and taking account, or having regard to, I keep saying taking account of it, having regard to the position of the bank by making clear the basis on which the order has been made. So when it comes to implementation, you better remember why. I come back to my point. Why is it any different from an order of damages in contract? An order for damage in contract. If that's what right as between the two contracting parties. Well, if a wife has a claim,
Yes, but it hasn't been made on any sort of assumption or premise relating to the assets or liabilities of the husband, the other damages claim, which is the point my Lord Justice Dingemans was just putting, I think.
if I come back to my point, I say that there is a first substantive potential prejudice to the wife, because the bank would then be saying, oh, we've got our judgment, you haven't got yours yet. It's now got to actually come off the top, which we say wouldn't be fair or appropriate. It doesn't follow that having regard to potential liability means it has to come off the top. And if one went back to Mr. Justice Peel and said, well, look, there's this order for 4.6 million, he said, well, I can't make an order then in favour of the wife, then the bank has achieved priority, hasn't it? For a non-proprietorial claim, it's achieved priority in relation to two non-proprietorial claims.
Well, it may be that the parties then will split whatever is left on a proper basis.
Well, if there were anything left, yeah. But the wife's case would be, well, you know, whatever the damages are, it doesn't follow that that comes off the top of what's divided up for the financial proceedings. But you see, what's going to be argued is, well, it does come off the top of the financial proceedings. But as a matter of law, it shouldn't, because the wife has an entitlement in law, just as the bank may or may not have an entitlement in law. And that's why I pray and aid Miller McFarlane. So I suggest the wife has that prejudice, but that's not the only potential prejudice to her. If an order were made now and the claim for damages was dismissed, the wife would have what we called below an oven-ready order, ready to be implemented after all these years of waiting. Surely the negotiations for this began in 2016. And she's still left in a position of uncertainty as to what her financial situation is. Whereas if she's then got to argue about it later on and go back and ask someone else, that's even more delay. If the order for damages doesn't come off the top and doesn't take priority, then why couldn't the order be made now? If the bank's claim for damages fails, there's a risk the husband might die in the meantime.
You keep telling me this, but it's making me very nervous, given that I believe he's only 60.
Yeah, but he is living in Ukraine.
61.
61. Still a mere child.
Yeah. He is living in Ukraine, and whatever Mr. Marks says about statistics, I think I'd fancy my chances rather less if I was living in Ukraine at the moment than
There's
living...
no medical, there's not been
living in
any
London.
evidence that there's any medical
No.
reason that he should have, not,
But
and apart from the issue of, I'd say apart from the issue
Yeah.
of the war, of course, that's a huge issue. I'm
Yeah.
not underplaying it at
But
all.
the fact is,
Apart from that, where he's living in a war zone, which of course
and the
does
fact
present
is,
high
people
risk,
do
there's no-
die, perhaps people don't die as often when they're 60 as when they're 75 or 80 or whatever.
Well, I
But
I haven't got my at-a-glance, but no doubt his life expectancy,
But this
the
isn't a
normal things would be into his 80s.
This isn't a statistical thing, my lady. It's a question of, is there any risk as compared with what we say there's no potential
You want
risk?
to put heavy emphasis on
to
the
the
fact
bank.
he might die.
So if you're looking at no risk to the bank that can't be dealt with by adding the conditionality and making clear the basis of the order, then even though the potential risk to the wife and the other things may be slight, may not be slight, there are still those risks. And that is one of them.
Okay, I'm speaking for myself. I'm entirely willing to accept that somebody aged 60 might unexpectedly die.
Or be run over by a bus and
yeah,
die,
or-
whatever, yeah.
I don't, speaking as a 60-year-old, I don't think I'm immortal in any way, shape or form. But can we just go back for a second to the conditionality? Have I got the conditions? The conditionality is this right? It's the foot of page 120 and page 121 of the
Paragraph 48 onwards of
Yeah.
the draft order.
right. So I've got it in supplementary bundle, page 120,
Yes.
121. It seems to be all directed at the worldwide freezing order, doesn't it?
Yes, it is, because that was what was...
But that's not the point, actually, with respect. I mean, the worldwide freezing order doesn't provide security or anything like it. It's simply there to preserve the position pending a judgment. And if there isn't enough to go round, there's an insolvency out there. I mean, this order would still be, as I understand it, waived in front of the trustee in bankruptcy and be proved in opposition to the bank's claim.
Yes, that's certainly right.
And on the face of it, it's a court order which doesn't entitle the trustee in bankruptcy to go behind it.
But it's a court order that...
Where does it say that actually this doesn't bind the trustee and the husband's trustee in bankruptcy?
It doesn't say that, but either it could, or a judgment issued with it could, make absolutely clear, as we have, and as the transcripts will make clear, it was made on the basis that this was a fair outcome as between the husband and the wife, without taking account of any damages awarded against him.
Does that mean it could be proved in the bankruptcy or not?
I don't know.
Isn't that rather an important thing to clear up?
Well, I don't know. That's the honest answer.
I mean, it just seems to me that this only goes so far. I appreciate everybody is only focusing at the moment on the worldwide freezing order because the proceedings in the Chancery Division are still up and running. But that's not going to be the end of it, is it? I mean, if there is a if there's no judgment.
If there's no judgment.
No judgment for the bank, not a problem.
Well, there's a problem if the husband dies in the meantime.
We'll come back to mortality in a moment. But in terms of then giving effect to the matrimonial order, there's no problem. But if there is a judgment in favour of the bank, and the bank seeks to take insolvency proceedings, bankruptcy, to enforce its judgment by way of bankruptcy proceedings, then there is an issue if you're clutching an order saying, I have a rival claim, which has been premised upon it. Maybe we have to assume it's premised upon the fact that the husband is saying, but I'm not liable, because that's what he's saying in the Chancery proceedings.
Yes, it's premised on the position as between the husband and the wife, and it's premised on the wealth as it existed at the time of the order.
Or even just going back to George and George, it's premised upon the husband in that case saying, well, I'm not liable in those other proceedings, and then suddenly turned out he was.
Well, it's not on a full basis because it's acknowledged here that the husband may be liable. He says he won't be. Obviously, he can't know that he won't be held liable. The wife has no idea whether he'll be held liable or not. But it's clearly premised on a situation without taking account of any damages that may be awarded.
But why would it not be provable in the bankruptcy, given that it would be a final matrimonial finance order, subject to the conditions in relation to the worldwide freezing order, which can be, under the insolvency rules, be proved in the bankruptcy?
Wasn't there a time when matrimonial finance debts weren't provable in bankruptcy? I asked
Yeah, but that's not the position anymore.
No.
I mean, the worldwide freezing order will fall away when there's a bankruptcy.
Yes.
Because the purpose of the worldwide freezing order is to protect a claimant from the inability to enforce its judgment in a private fashion. The bank would take proceedings as any other successful claimant to execute over assets for its own benefit. But if there is, and the bank may well decide that's what it wants to do. I mean, why does it care about other creditors? But if in fact there is an inadequacy of assets and other claims upon them, then there should be a bankruptcy in which the bank will just have to prove like everybody else. But the worldwide freezing order will then fall away, save to the extent it would have protected the assets, which then are handed over to the trustee for distribution amongst all creditors.
But I asked this rhetorically, why shouldn't the wife be able to prove in bankruptcy?
I'm not saying that she shouldn't.
No.
She should, obviously, but on the basis of an order that has properly taken account of the fact that there are other claims on the husband's assets. That's the argument you face, I think.
But why is that a different position from if she was a general civil litigant? I know your lordship's going to say because a claim is based on a pot that's available or not.
Well, that's what George and George did say, was that wait until you know what you've got, and then you can divide it fairly. If this was a fair division, knowing whether this was a good or bad claim, no one would have the problem. But all Mr. Justice Peel has said is wait until after June when the trial will take place.
But then I come back to the question of what happens then. Is the pot for the purposes of matrimonial finance proceedings automatically reduced by the amount of a damages claim, albeit it's a non-proprietorial claim and the wife's claim is a non-proprietorial claim?
Well, it happened in George and George. That'll be for the judge and the family division. And you rightly pointed out a situation where a wife had been able to persuade the court that it was fair and just to give the husband's half share in her house to her so that she could stay there with her 2 children.
Going back
That's
to
a million miles away from 100 million.
But going back to George and George, I do maintain my position that no one would be misled by this order. It's not made on a false assumption. It's made on the basis that there is a claim for damages, which may or may not succeed. and that the order is not enforceable. I mean, it may be said that it's not enforceable, which means it's not provable in bankruptcy.
you
I
accept-
appreciate it's not what it says in terms, but it could be construed as not
Well,
provable.
yeah, I mean, bankruptcy is a collective enforcement process. So
Yes.
you might argue, it might be argued against you that enforceable means you can't prove it either. But
Yes.
I rather think that ought to be made clearer than it
Yes.
is, if that's the intention.
Well, these are the
But-
things
but
that-
you've indicated it's not.
Yeah.
You would resist that.
But these are the things that were not debated before the judge, and the order was made, or the matter was stayed on a rather more, I submit, superficial, without being pejorative about that basis, than this.
Can
But
you,
there is returning.
sorry, just before you leave the order, can I just ask you one question about paragraph 48? Because you've been telling us it's no part of your intention to go to the courts to vary the freezing order, let alone if there's a bankruptcy. But if you look at paragraph 48, line 4, it says, such date, if any, as Privet Bank worldwide freezing order is conclusively discharged or varied by a competent court to the extent necessary to permit such implementation or enforcement. And that's implementation or enforcement of this agreement, isn't it?
Yes.
So that is expressly preserving you the right to trot off to the Chancery Division.
We're preserving the rights to go off and do that.
Well,
but
why do you want to do that if all that you're saying, including the bits in the
just to
Word
keep all the options open. But if you look at the witness statement of the appellant in the supplemental bundle,
Well, you might understand that people might not give much weight to a witness statement, which may have been her perfectly fair intention when she drafted the witness statement, but if her options are kept open, no one's going to keep her to it.
what she says in, sorry, it's paragraph 10 of her witness, if anyone wants to look at that. As I say, looking at it from a legalistic point of view, one wouldn't hold out very great hopes for having the order varied in these circumstances. And in any event, Mr. Marks or whoever represents the bank in such proceedings would be there to argue the bank's case as to why it shouldn't be varied.
In paragraph 10, she doesn't say she's not going to go.
No, she doesn't say she's not going to stone.
She says it's an option.
One of the options. Yeah. Because it's clearly an option. And that's just following on from the old Tatneft provision. It's one of the options that are open to her, but rather more important is to actually have the order signed and sealed and approved, as it were. But even if she made the application for a variation, it would be clear to the judge who heard the application the basis on which it had been made. It wouldn't be possible for her to wave it around and say, here's this order approved on the basis that I'm entitled to this come what may, and it fully takes account of any potential liability of the husband in damages.
No, but what she might say is that this is an order which has been approved on the basis you've outlined as a fair order. At the moment, I'm down to my last 4 million, and I really need some money to provide for myself and these 4 children appropriate outgoings necessary to maintain myself and these 4 children. And as you can see, when I say, please, can I have 30 million to be going on with, that's only a tiny dent in the amount of money at stake. But this order makes it clear that, I'm entitled to very much more than that, so please vary it and let me have some.
Not that I'm entitled to it, but as between me and the husband alone, I'm entitled to it. But why shouldn't she make that application as long as
I'm
it's...
just saying I was
No.
presuming some such application of that nature was almost inevitably going to be made. I'm kind of slightly surprised that you're rather backpedaling from that.
But there would be nothing unfair about an application put on that basis. Not that I should have the whole lot released to me now, come what may. But there will be no harm or nothing unfair to the bank in saying that. She couldn't wave around the order and saying, oh, look, the judge decided that come what
I'm
may
not saying
in
it was,
relation...
I'm just saying let's look at the realities of this.
Yeah.
It would not be even remotely surprising when
Right.
represented as she is, that such an application was made.
But what the bank was saying it was worried about was the wife going along and waving an order and saying, well, this is...
Yeah, well, she would
what
be
I'm
waiving the
entitled
order because she'd say the
Yeah,
agreement's
she would.
100 million, The judge has said that's a fair outcome. I appreciate things are a bit awkward in the Chancery Division at the moment, but I need £30 million to keep me going.
But it would be clear that it's a fair outcome as between her and the husband. It will be clear that it takes no account of the damages claim, and it wouldn't be misrepresenting the position at all. And it could be argued against it, that basis being absolutely apparent. Insofar as it's not crystal clear from the order, it could be made crystal clear in a judgment.
But I'm still struggling to understand whether you accept that the order would either fall away, or have to, or could be reviewed or revisited in some way at a later stage in light of the judgment in the Chancery Division.
I can't think how that the order could be reviewed unless or changed unless someone applied to set it aside.
Well, hence my question.
Yep.
See, because a scenario which I don't think is a million miles from a possible scenario is, let us say the bank recovers a judgment of a material amount. Husband declares himself bankrupt, says he can't pay. The trustee in bankruptcy advertises for claims. The bank has its judgment debt. Wife turns up with this order and says, right, well, we should share now pari passu in whatever assets the trustee can recover. Okay, trustee sets off to recover. Maybe only recovers assets in this jurisdiction, whatever they are, or maybe has some success in other jurisdictions. The bankruptcy then comes to an end. Assume husband is fully compliant and discloses his assets. The bank will be maybe unpaid a proportion of its debt, but it will be discharged. The wife's debt will not. Now, in those circumstances, part of the assets that were available in the bankruptcy will inevitably have been paid to the wife on the footing of an order which took no account of what turned out to be the judgment in favour of the bank. Is that...
Yes, I see it, but it's this, where does one break into this circle?
Well, exactly. It's the question we're posing. But is that an outcome which the law should countenance when it can make an order in the matrimonial proceedings on the basis of actual knowledge if it waits a bit?
Well, what we're concerned about is on a return to Mr. Justice Peel, if there's an order for very substantial damages, it being said, well, that has to come off the top, come what may. That's now a hard obligation on the part of the husband.
Well, as my lady put to you some time ago, if there wasn't a consent order, the attitude of the judge might invariably be, I'll wait until I know what the liability is. Well, why should the position be any different simply because there's an agreement?
Then what does the wife get for her earned endeavour?
Well, the same as any wife of a destitute husband when there are no assets around. I mean, she may be right in thinking that he's worth 5 million, but if in fact he's worth 0, then obviously there's less to be shared.
But if she can prove in the bankruptcy for any order that is properly made.
But if you have a straightforward poker application in the Crown Court, absolutely no regard is taken for the adverse consequences to a spouse and their child when deciding what confiscation order to make. That's Webber and that line, isn't it?
Going back to my Lord Dingemans' point, you are then, aren't you, prioritising a non-proprietorial claim by the bank?
No, what you're doing is splitting up the assets that actually are available to the parties.
Which is prioritising a non-proprietorial claim by the bank against a non-proprietorial earned entitlement by the wife, if one takes that off as a debt. Because, as I've tried to point out, Section 25 doesn't require you to take it off. it requires you to have regard to it. And I'd better finish off because
Well,
Mr. Howard is champing at the bit, let alone Mr. Marks.
well, I'm sorry, Mr. Turner, we've bombarded you with questions, but
No, it's helpful
I
to
think
know
you're
the
up
way
to
that
it.
the court's thinking. So then there's the other potential prejudices to the wife if the order isn't made now. And there's if the husband should die in the meantime, she can't enforce the order. Well, she's got no order to enforce, and she can't, as the law stands at the moment, make a claim for financial remedies or under the inheritance proceedings because the husband's not domiciled in England.
So just so I'm clear, the order is a requisite for proving in the bankruptcy.
For doing what?
For proving in any bankruptcy.
Yes.
So the risk that you identify in the scenario that I just put to you is that unless there is an order, the wife would not be able to prove at all
In bankruptcy.
in the husband's bankruptcy.
Or be able to make a claim against his estate, even if the claim for damages was dismissed. This is the danger here. If the claim for damages was dismissed and the husband had died in the meantime, the court wouldn't be able to make the financial remedies order because the cause of action, as it were, as the law stands at the moment, although the Supreme Court's considering it, wouldn't extend beyond the husband's lifetime. That's Harb and King Fard. And she wouldn't be able to replace that claim by claim under the Inheritance Provision for Family Independence Act because the husband wouldn't have died domiciled in England unless something unforeseen changes before his death. Then there are, and we've set this out in writing, important provisions of the proposed order which require the husband undertakes to take steps to divest himself of any status as a potential beneficiary within the trusts. And unless we have an order that enables him to do that, that requires him to do that, he's not going to be doing that. The Jersey court's not going to approve any step without an order. If you look at paragraph 33 of our draft order, which pretty much acknowledges that. And yet the bank has no legitimate interest in that because the funds in the trust are not, save for the repayment of the loan, which I've mentioned, are not assets which belong to the husband. And yet the wife is stymied from enforcing that part of the order which enables her to benefit from that, at least. So, as we say, there's no prejudice to the bank in letting that go ahead because the bank wouldn't be able to enforce against any funds in the discretionary trusts anyway. And then those are the potential prejudices, the wife, over and above the general prejudice. What I also pray and aid is the submissions that both I and Mr. Howard made before the judge, which are there in the transcript, and you can see. There is my ground 6 about the costs. I don't think there's anything I can add to that.
No,
what
we've
I've
got
said
that in writing.
in my position statement, so I don't think I need to say anything more about that. I appreciate the judge reduced the cost claim, but without doing the proper assessment, a line-by-line assessment, it was still, we say, far too high, and as a matter of principle, this ought to have been a detailed assessment, not a very superficial assessment, because the judge didn't actually address the points that we'd raised. Lady, my lords, those are my submissions.
Mr. Turner, we're going to effectively hold you over the short adjournment. It just may be that Lord Justice Snowden may want to just tease out a couple more issues in relation to trusts and death, but he'd like to just have a think about that over the short adjournment. I think we're all right for time, aren't we, gentlemen? Mr. Howard? How long do you anticipate being?
I don't anticipate being that long now.
No,
I mean, I really, I think I've done something in writing.
You have.
Also, you've got my submissions that I made before Mr. Justice
We
Peel.
have.
Rather unusually, having reread them, I don't really want to alter them.
Excellent. That's always very satisfying.
Well, I was rather pleased to see that. And I was really going to deal with, I hope to start off with the points that have arisen today. And I wanted to refer to Radmacher, which we say is
All right.
really very
So,
significant.
but what's your best guess?
I'm thinking about half an hour.
All right, thank you. Is that going to leave you in difficulties, Mr. Marks?
I'll have whatever time I have left, my lady.
Excellent. Thank you. Very well, we'll say 2 o'clock then. Thank you all very much.
All right.
You're going to lock up, aren't you?
Yeah.